recent updates on wills and estates. And I looked at the topic last night when I was going through the very comprehensive papers that John Nunns and Andrew Verspaandonk, who is on his way on a train from Geelong, have written, and I thought, recent updates, why? What's so recent about it? People have been having wills and estate disputes since the 16th and 17th century. And then I thought, no, but there's been lots and lots of changes in this area since the Act changed 10, 12 years ago. And then I reflected, and Queen Elizabeth II's Diamond Jubilee has been on the last couple of days, and I reflected further. And I thought there has been a lot of change. We have had the agricultural revolution, we have had the industrial revolution, we now are going through the technological revolution. People are preparing and planning to have private flights to outer space, funded not by governments but by wealthy billionaires. My husband reminded me last night that even the Queen has an iPhone, an iPad and a mobile phone in her little black handbag. So there's been lots of changes, but there hasn't in this area of the law, because this area of the law is a very old area of the law, and it dates back to many, many centuries ago. And I was reminded of the fictional court case of Jarndyce and Jarndyce. It's the court case in Charles Dickens' excellent novel Bleak House. And the case concerned the fact of a large inheritance. It dragged on for many generations prior to the actual commencement and the action in the novel. And by the time it was resolved late in the narrative, legal costs had devoured the entire estate. So you may say, what's changed? The case is thus a byword for an interminable legal proceeding. Even Lord Denning, in the Midland Bank versus Green case, said, "The Green saga rivals in time and money the story of Jarndyce and Jarndyce." Charles Dickens used it to attack the Chancery Court system as being near totally worthless. And as any honourable man among its Chancery legal practitioners says, and I quote, "Suffer any wrong that can be done you rather than come here to the Chancery Courts," end of quote. All the main characters in Jarndyce and Jarndyce are connected in some way through the case, though the actual legal proceedings only appear as a background plot. Aside from the lawyers who prosecute and defend the case, every character who directly is associated with the Jarndyce and Jarndyce case suffers some terrible tragic fate. Miss Flight has long since lost her mind when the narrative begins, and Richard Carston, another main character, dies trying to win the actual inheritance he was aiming to win for himself. The first chapter is really, really interesting, and again, nothing much has changed in deceased litigation. People are born, people die, and people will contest wills and unfortunately fight over wills. Jarndyce and Jarndyce droves on and on throughout the book. The scarecrow of a suit has, in the course of time, Charles Dickens says, become so complicated that no man alive, let alone in the Chancery Lane, knows what the case is now about. The parties to it understand the case at least, but it has been observed that no two Chancery lawyers can talk about it for 5 minutes without coming to a total disagreement as to all the premises and issues in the court case. Innumerable children have been born into the cause. Innumerable old people have died out of it. Scores of persons have deliriously found themselves made parties in the Jarndyce and Jarndyce suit without knowing how or why. Whole families have inherited legendary hatreds, greed and enemies within the suit. The little plaintiff or the little defendant who was promised a new rocking horse when Jarndyce and Jarndyce should have settled long ago have grown up. They've possessed and bought themselves a new real horse, and they've trotted away into the other world. Fair wards of court have faded into mothers and grandmothers, a long procession of chancellors has come in and gone out. The legion of bills in the suit have been transformed into mere bills of mortality and costs. There are not 3 Jarndyces left upon the earth since the case started, perhaps since old Tom Jarndyce, in despair, blew his brains out at a coffee house, where else but in Chancery Lane. But Jarndyce and Jarndyce still drags on, drearily, lengthily, before the court. Commentators over the years have speculated and theorised that the novel Bleak House, and in particular the fictional court case of Jarndyce and Jarndyce, was inspired by an actual dispute over a will of the father-in-law of the 18th century writer Charlotte Smith. And that actual Chancery case involving a disputed will took 36 years to get through the Chancery court system. So, what's changed? The 2 papers today will look at firstly, John Nunns will look at the recent updates in various areas of deceased estate litigation, and then Andrew Verspaandonk will look at the family development of TFM family, testator's family developments that have occurred, and both barristers have looked at the most recent cases in Victoria and other states of Australia, and they're very comprehensive papers with, cases as recent as a few weeks ago. Firstly, John Nunns. John has been a practising barrister since the mid-70s, and he has a very extensive, broad practice. It's fair to say he is one of the most senior juniors on Michael Green's list. The qualities that John has as a barrister are his persistence, his real attention to detail, and may I say from a personal note that he is a thorough gentleman, even during the heat of the litigation battle. Ladies and gentlemen, John Nunns.
Good morning, ladies and gentlemen. Thank you, Georgina. I, also speaking from personal experience, can return the compliment because Georgina is one of the very best mediators anyone could have in this area, and I have recent experience which has dragged Mr David Hughes into the Jarndyce and Jarndyce, but a family dispute originally came to court as a will construction dispute. We retaliated by trying to remove the executors and have them replaced, and Georgina just a week or 2 ago managed to persuade, cajole, bully, dare I say, work on the parties to a settlement. The work that Georgina puts into her mediation, the feeling, the empathy, it is truly terrific. And to avoid the Jarndyce and Jarndyce result so that the beneficiaries actually benefit rather than the lawyers having a wonderful time and listening to their wonderful mellifluous tones persuade judges about wonderful abstruse points that nobody else understands. I'm doing the paper on the non-testator's family maintenance, or family provision as it's now called, area of wills and estates, and I won't have time to go through the whole of my paper. My objective is to update your knowledge in the sense of providing you with reference to the cases that are discussed in my paper. And my paper is a reference source and a resource for you to refer to from time to time afterwards. I will only be discussing what I consider to be the more important aspects or aspects of more general application. And my paper's in 2 parts. Last year's practice note setting up the probate list. 28th of April last year, that practice note came out and it set up the specialist probate list. and the second part is case note summaries. My paper, I remind I look around and I see there's plenty of experienced practitioners here, but in case a busy practitioner resorts to my paper as the be-all and end-all, it's not. You need to look at, if you don't know the area absolutely brilliantly well, you need to look at a textbook to put your problem in the context of the law in that area, check your relevant statutory provisions, and read the whole of the case referred to, because law is, in this area particularly, is applied to people and the circumstances they find themselves in. It isn't a simple proposition that you can stick on like a paper flag on a page and say, that's my case, that, because it all depends so much on the factual context. Practice Note 5 of 2011, as I said before, it sets up a specialist probate list and there's a specialist probate judge. It was Mr Justice Habsburger, who I believe is currently on leave, and one of our former members of Michael Green's list is now Justice Macmillan, and she's handling the management of that list. The important things to realise about that list are what's in it and what's out of it. It doesn't cover everything, and particularly it doesn't cover family provision. Family provision is sometimes decided by full judges and some by associate justices. What's in the list? First of all, obviously, applications for grants of representation, grants of probate or administration, which are referred by the registrar to a judge. As you'll no doubt, all those who practice in the area will realise, the registrar does the great bulk of the uncontested or straightforward applications for grants of representation. He is statutorily prohibited by Section 12(2) of the Probate Act from handling those cases where there's a contest which has been initiated by a caveat, and the caveat procedures in the relevant chapter of the Supreme Court rules, and those cases are automatically referred to a judge. You're required to take out a summons for directions, but the other category that's also excluded from the jurisdiction of the registrar are those cases where the registrar forms an opinion and has a real doubt as to whether a judge would or would not grant probate. So they're the things that are automatically included. The first step that are included, what the registrar refers to a judge. The second category is caveat matters, which I've mentioned, because those caveat matters are excluded from the registrar's jurisdiction anyway. And you go through the caveat procedure, those of you familiar with it will notice that you lodge your caveat against, for example, a grant of probate, and then the registrar notifies those interested. Then you put in your grounds of objection, setting out in more detail the basis of your objection, whether it's lack of testamentary capacity, undue influence, whatever. More than just, I don't like the executor named. But then it's incumbent on one of the parties, if one not the other, to take out a summons for directions, and you get before the judge. The third category of what is included in the probate list is applications for limited grants of probate. That is, those that aren't for the whole administration of the estate, those that were formerly dealt with by a judge in the practice court. Applications that are limited with respect to the subject matter of the administration or with respect to the time over which the limited administration takes place. And they give you the examples of ad collegendum bona for collecting the goods of the deceased. That's to preserve property, things that are in a hurry, and it includes goodwill of a solicitor's practice. Ad litem for the purposes of the suit, where it's necessary that the estate is represented in litigation and for some reason or other the named executor is unwilling to take it on. Or pendente lite, pending the suit, and that's the sort of things like the validity of the will, contested probate, and they're specifically mentioned by Section 22 of the Administration and Probate Act. Fourth category that's included in the list, applications for revocation of grants of probate, and I have in the second part of my paper, I've referred to a recent case note in Part 10, which involves an application for a revocation of a grant of probate. Applications for rectification of the will, you will know, those who practice in the area, that Section 31 of the Wills Act authorises a court to rectify wills to carry out the testator's intentions where they can be ascertained by the particular judge. And there are case notes in Part 3 of the second part of my paper that give you examples of cases or where applications were made for rectification of a will. The next category is matters in which a party seeks construction of a will, and there's a few examples of those that are also given. Other matters arising under the Administration and Probate Act, excluding Part 4. Family provision, as it's now called, testator's family maintenance for those who are of my vintage. The next category is other matters arising under the Wills Act, and examples which I deal with in the paper are under Section 9, where the court has the power to dispense with the formalities required by Section 7 of the Wills Act for a valid will. That section begins that the will is invalid unless, and then you've got to comply with those formalities. Another matter that is arising under the Wills Act is the court's power under Section 21 to authorise a will to be made for a person who lacks testamentary capacity, and there's a case note reference to a recent case decided by Mr Justice Bell of the Victorian Supreme Court, who it's a very good illustration of the sort of evidence that you need to make your application if you're going to succeed under that application. And the last category is whatever you can persuade the judge should be in there. Matters which, in the opinion of the court, ought to be included. What is excluded under the practice note are applications for grants of representation not referred by the registrar, that is the great mass of non-problem applications, no caveat and not doubtful. Matters arising under Part 4, that is testator's family maintenance, as I've already referred to, and executor's commission, the detail of executor's commission. They're dealt with applications under Section 65 of the Administration and Probate Act. They're dealt with outside this list. The only other things that you need to know are you've got to endorse your paperwork with the words probate list, as well as all the other usual endorsements referring to the specific statutory provision or the will or the estate. No additional fee to get into the list, and directions days, I think they're still specified in the practice note as Thursdays, but they are in fact now Fridays. And the judge in charge, Justice Habsburger, particularly encourages minutes of order to be circulated between the interested parties well in advance and hopefully end up being consented to. I say in the paper 2 days before the hearing, being Wednesday for Friday, but on reflection I think it's far safer if you get them in by Tuesday rather than Wednesday, and your routine directions are expected to be dealt with by consent. The thinking is that there has been far too much waste at the benefit of the legal profession in this area of litigation. Just because it's a directions day doesn't mean that the judge won't deal with something urgent. And I had a recent example of also applying for an urgent interim injunction by summons that was returnable on the directions day, and despite my colleagues' wish to put in answering material and have the matter adjourned off when he refused to give the undertaking that we sought to preserve the status quo, His Honour Mr Justice Habsburger listened to the pair of us and said start at 2:15. And that had the miraculous result that the undertaking that was sought was forthcoming, and His Honour didn't have to deal with it after all. Mr Robin Chan, His Honour's associate, is a most helpful person. If you want to know about what process for the application, ask him, because he is both expert and helpful. And to tell a story against myself, Mr Hughes and myself had a slight difference of opinion as to the appropriate process to, it's too complicated to mention, but competing grants. Mr Hughes's grant being for letters of administration with the will annexed, and the other competing grant being by the executor named in the will applying for a grant of probate. And Mr Chan helpfully suggested that all we needed was the summons for directions in each of those applications to get it before the court. We didn't need what I was thinking was the correct way of doing it, a fresh originating motion asking for the named executor to be passed over. And that's the way it was dealt with. Just the two summonses for directions with a supporting affidavit. Now move on to the case law updates, because we're going to run out of time. I'll gloss over the first one, which is on the paragraph B1.1, mutual wills or contract for the survivor to leave property as agreed. That just shows that what you can't do by going in the front door, sometimes you can do by going in the back door. The complicated doctrines of mutual interdependent wills wasn't what was used there, but the court found that there was a contract between the parents in relation to the way they were to deal with, the way the survivor of them was to deal with the property, leaving it to the blended families. And after the husband died, his surviving widow changed her will to favour her natural-born daughter, and the court found that there had been a contract between them. And the question that's somewhat novel is, how is that contract enforced? That contract turned into a trust when the husband died and the surviving widow changed her will. Because of that unconscionable act, that created a trust which was enforceable by the beneficiaries. Then I move on to the area of informal wills. The first category I deal with is simply those wills which are valid, but somebody's lost it. And that's a matter of evidence, matter of proof, and you can prove that by a copy. And examples are given there. The second case dealt with in the will of Brian Lindsay O'Connor, that had a double problem, because not only had the original been lost, but the original was invalid anyway because it didn't satisfy the formalities of the equivalent, Queensland equivalent, I think it's the Queensland equivalent, of the Wills Act. What, as I said before, Section 7 begins, a will is not valid unless it's in writing, signed by the testator, in the presence of two or more witnesses present at the same time, and at least two of those witnesses attest and sign the will in the presence of the testator. Mr O'Connor had made his own will, and he'd handed it to his wife and said, "This is my will." She lost it, so they didn't have that, but luckily he'd given a copy of it to one of his daughters, and he told that daughter that he had given his will to his wife, and it wasn't witnessed. Another major problem. The original had never been witnessed. Why? Because he didn't believe that it was necessary, and luckily he had told his wife that he didn't think it was necessary to have a witness. And that will was, the copy will was admitted to probate. The copy given to his daughter, the unsigned and the will that was never attested. Fry and Lucas, that is a good illustration of factors in favour and factors against. The factors in favour, this was a will that came by a stationer's kit. Factors in favour were the document was signed and dated twice. He tore up his earlier will. He gave the later signed and dated document to his solicitor. What did he say to his solicitor when he gave it to him? His solicitor forgot. By the time it got to court, he couldn't remember. He told the deceased also told the plaintiff not to open an envelope containing deeds to a property that was a subject of a gift in the will to the person he'd given it to, not to produce these deeds until after his death when the will is being read. So those favours, the plaintiff certainly thought that he had a pretty good case for this document being the will. The factors against held sway. They were the reference to the wording of the will wasn't clear what that was about because it doesn't identify any particular document. Another factor that the judge found persuasive was that the deceased knew from writing out by hand the attestation clause of his earlier will that two attesting witnesses were needed, but His Honour did say perhaps he forgot. When you look at the date of the earlier will being 1967 and the later document being 1996, 29 years later, I don't think that it's a terribly powerful factor to say that he knew because of what he did nearly 30 years earlier. More importantly, the stationer's will kit had directions saying that it did need to be attested, and that was underlined, and as the document had been in the presence and the instructions had been in the possession of the deceased, the judge thought that was a reasonable indication that the deceased knew that the will should be attested. Another factor was that a clause referred to another property other than the one where the person had the deeds given to him, but that clause was clearly incomplete because it only dealt with part of the proceeds of sale of the particular property, and the names had been originally left blank in the typing and then had been written in, but there was a provision exempting one family, but that family who were to be left out hadn't been in. So the judge is starting to get the idea that this is a draft, this is incomplete. That is accentuated by different coloured inks being used in different parts of the document and writing in one colour being written over in another, looking more and more like a draft. The crucial factors are that he told a witness that certain persons were his executors, and this was after the document had been given to the solicitor, but those persons weren't the persons named in the document. He also told his sister 4 years after this document had been given to the solicitor that he had not finalised his will, and luckily his solicitor could remember that a conversation in the street 3 years after having given him the document that he was still sorting out his will. In those circumstances, the court decided they could not be satisfied that the deceased intended this document to be his will. Then I refer to a Victorian case, Mr. Justice Beach. It's very instructive from looking at all the evidence, and the conclusion he reached was also this document was a draft to be given to a lawyer for finalisation. Don't have time to go into the other cases, but they do indicate that the courts look very, very carefully, and that what's important to realise, there's a distinction between intending to make a will in the terms of the particular document and intending this document to be the will. And the statutory power only applies where the court is satisfied that it is this document that the deceased intended to be his or her will, not that the contents are identical with this. Construction, no point in mentioning the cases on construction, because every case on construction depends on the particular wording, and if you can find a case which is exactly the same wording applied to exactly the same factual situation as you are, you're a very lucky person, because in my long experience it virtually never happens. There's always something slightly different. One case of perhaps more general application, though, in this day and age is Trust Company and Zedilla. It's at 4.6 of the paper, and that concerned the construction of a bequest of a house property and substitute house property that I may own at the date of my death. She didn't own anything because she was in a retirement village under a sublease, and all that provided in the event of her death was the euphemistically named exit benefit. And her exit benefit that was payable by the corporate owner of the retirement village was what was argued to be a substitute house property that she owned. And the court said, yes, in the circumstances, the proper construction of the clause was that that entitlement was payable under that particular clause dealing with substitute house property that I may own at my death. Ademption, you will recall that that's where there's been a complete or partial extinction of a legacy by an inter vivos act of the testator other than by revocation. And the first case that's mentioned there is Simpson and Cunning. And when you go to that case, you'll see that the expert, knowledgeable counsel who argued that case for the plaintiff is my colleague, Mr. Andrew Verspaandonk, for the plaintiff executor, who took out an application for directions, and he also submitted that the gift was not deemed. The reason it wasn't deemed was that although the testatrix's house had been sold, she left it to her son. Although it had been sold by her attorney under an enduring power of attorney, she lacked testamentary capacity at that time, and there's an exception to the ademption principle where the person, the giver, lacks the intention to divest the property. And the case, there's a Queensland case, re via tel, that was not only followed but extended for the application in that case. If you've got any questions about Simpson and Cunning, I think Andrew's here and he'll be no doubt very able to answer that. Presumption of revocation, I think I'm going to run out of time. How am I doing for time? 2 minutes. Need to move along. Move along to removal of executors, because that's what Georgina and I were recently involved in. McKerricker and McKerricker is a good example of where an executor has to go. Two brothers, one of them moves into the late father's house saying he's going to sort it out and get it ready for sale. The brothers have got expert estate agents' advice as to what needs to be done. Time passes and nothing seems to be done. And that's exactly what happened. The brother who was in the big house liked it and did nothing. And he told his brother he'd done everything. He also told his brother's solicitor he'd done everything, but they had an agent inspect and nothing had been done. The judge had no hesitation in throwing him out, removing him as executor and removing him from the property, because he was preventing the due and proper administration of the estate. Chesney and Tonyola is a different case, and that relies on conflict of interest. Conflict of interest has become quite a popular choice of an excuse to remove an executor where people don't have anything better. But what you've got to show, though, it really is that the estate there is either in jeopardy or that the due and proper administration is being prevented. And that in that Queensland case, the judge said he wasn't satisfied in the circumstances. There were numerous conflicts. There were 3 proceedings on foot. The executors were accountants who had been involved in giving advice in relation to a transfer of shares that those who didn't benefit, who are the plaintiffs in the various proceedings, wanted set aside. And the argument was there's a clear conflict of interest. These accountants will be trying to justify their position. And the judge said, no, there's no evidence before me that shows that they're not going to carry out their job effectively or impartially. And he refused to remove them. Revocation of grants is another, it's the way executors are removed. Apparently in New South Wales there's debate over this in the Wills, Probate and Administration Service. And this case is South Australia, and apparently that's the way it's done, where you've got 3 executors, you revoke the grant and then you re-grant to the 2 that you don't want to get rid of. But what's interesting about that case is that it was one of the executors who wanted out. As the judge described it, it had an element of cutting and running. I'm not too sure what that means, but it did yesterday afternoon. I tried to look it up. And I think the notion is somebody who wounds and then runs away. And the judge looked at the consequence of what would happen if this executor was removed, the executor company. The executor company said, we want out. They've accused us of a conflict of interest, and the conflict arose because one of those executors had claimed that the trustee company, the executor company, had given negligent advice that had caused the estate to incur millions of dollars of inheritance tax liability under United Kingdom inheritance tax provisions. And when the executor, the other co-executor, made that accusation through his solicitors, the executor company said, well, conflict of interest, we're out of here, you sort it out yourselves. And the judge found another conflict. The judge said, well, not only is there that one in the professional negligence type case, but under the legislation that's exhibited in the documents before me, the people who are going to be liable to pay this tax are the executors. If I let you out, these poor 2 individual persons have got a tax liability of millions of dollars which they will have to recoup from the beneficiaries who will fight them. In those circumstances, this is probably what His Honour meant by cutting and running. And in those circumstances, no, I'm not going to let you out. Yes, there's not only the conflict of interest you've placed before me, but there's the conflict of interest that I've discovered myself from reading the legislation and the materials. Two bad conflicts, but this can be handled by a responsible executor trustee company making applications to the court for directions if and when problems arise. And the judge said he had no doubt conflict of interest problems would arise, and it may mean that eventually that they had to be removed. But at this point in time, he wasn't leaving the two natural persons to shoulder the millions of dollars of tax liability from the UK. And that's just another example of you can't look at a label and say conflict of interest and say that's the be-all and end-all. And I think I've probably run out of time. When I get to the end, though, you'll see this paper was done for the Law Institute a few months ago, and I couldn't find any novel cases in the Part 4 area. Andrew's excellent paper, in-depth analysis of recent family provision cases, that goes to the next level. That goes to the more exacting level of seeking to identify trends which may assist you in advising your clients. Thank you very much.
Just before John leaves and we welcome Andrew Verspaandonk, are there any questions of John? Probably take two questions. No questions? Yes, sir.
Excuse me, John. A number of the cases you've cited are interstate. In your experience, single judges deciding probate cases here, how persuaded or otherwise are they by those decisions of single judges?
They're persuaded by the reasoning rather than just being there being a judgment. It's similar to those very old cases that you get in an old textbook, and you go away and you look for the reasoning, and you see, you know, blogs for plaintiff, dags for defendant, order that he be removed as an executor of the estate. And when you put that before the judge, he says, well, it's not very persuasive, is it, Mr. Nunns, because it doesn't tell me why. What they'll do is look at the reasoning and give it the respect that they consider that it deserves.
Excellent. Thank you, John. As always, very well prepared, attention to detail and delivered in a very clear manner. Thank you, John.